Good afternoon, Your Honors.
Good afternoon.
I'm Derek Fairchilds. I represent the appellant, Jacqueline Payne. If I could reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Thank you. Your Honors, this is a Governmental Tort Liability Act case that's based on a motor vehicle collision that occurred on June 16, 2021 in Shelby County. My client, Ms. Payne, was a passenger on a Ford Econoline shuttle bus that was at a stop at a red light when it was rear-ended by a Dodge Charger operated by a Shelby County Sheriff's Deputy, Vincent Jennings. The impact from that collision caused injuries to Ms. Payne's neck, her back, but most significantly to her right shoulder. She sustained a torn rotator cuff to that shoulder that required surgery, ended up in a permanent impairment for her. This matter proceeded to a bench trial on March 6th of last year, I believe, in Division 5 of Shelby County Circuit Court in front of Judge Rynette Hurd. And Judge Hurd found that while Ms. Payne was injured, she found that the neck and back were injured. She found that the right shoulder injury was not caused by the wreck. And so the main point of contention on this appeal is that I feel like the evidence preponderated against that decision and instead preponderates in favor of the right rotator cuff tear being caused by this rear-end collision. At trial, virtually all the evidence that was presented preponderates in favor of the rotator cuff tear, and I'll just summarize briefly for your honors. Dr. Apurva Dalal, he's a board-certified orthopedic surgeon who specializes in shoulder injuries. He treated this injury. He testified, and he testified repeatedly, consistently, without a doubt, that this wreck caused the rotator cuff tear.
There seems to be some confusion or some disagreement as to the doctor's specific testimony regarding this wreck and the shoulder injury. And in fact, I believe the trial court judge found that although the doctor had said this was, I believe, a work-related injury, that at no point did he specifically tie the shoulder injury to the subject automobile accident. And I haven't looked at your record, of course, but I've read your briefs. Is that an accurate summation, I guess, of what the court found?
Your Honor, I do believe that the court was a little confused or maybe overlooked some of the testimony. I do believe that the court found that there was some confusion about the work-related injury and whether that was the motor vehicle collision. But Your Honor, Dr. Dalal testified repeatedly during his deposition that was presented at trial that the wreck was the cause of the rotator cuff tear and that there was no other issue. You know, I think this honestly, it might be the result of the circuit court no longer handling comp cases any longer, because Judge Hurd almost took the work-related injury in a negative fashion, whereas in reality, this was a work-related injury. My client was working for Signature Healthcare as a CNA at the time this wreck happened, and so she did treat through comp. All of the medical records, not just Dalal, but all of them reference, and rightfully so, a work-related injury. This was a work-related injury. She was on the job at the time. So I think there was some confusion, I believe, on Judge Hurd's part about work-related injury. But not only Dr. Dalal's testimony, but also the medical records are very clear, Dr. Dalal's in particular, about, torn rotator cuff tear is the assessment. Motor vehicle collision, work-related injury. I mean, it's every visit, he's saying those things over and over again. So that's kind of
preponderates is a pretty high hill to climb on appeal. Is the key here that the absence of countervailing medical evidence and the fact that certain factual findings on which the trial court grounded the ruling, you essentially are arguing are just wrong based on the evidence that was presented?
Yes, Your Honor. So I do believe there was quite a bit of evidence that preponderates in favor of the causation of the shoulder injury. And then, yes, you're right. I mean, there's almost no countervailing evidence. The defense case in chief, there was none. The only evidence they presented was on cross-exam of the witnesses that I called, and even then it was very minimal and nothing really of substance. And so there's very little on their side of the scale. Our side of the scale has quite a bit of evidence, and theirs doesn't have much. And then, yes, I mean, you're exactly right. So the findings of fact that the trial judge used to support her determination, a lot of them are just objectively wrong. And I don't want to be critical, but I mean, you can just look at the medical records where, Judge Hurd is saying, well, there's no mention of shoulder pain in the physical therapy records. And I mean, just look at the physical therapy records. The pain was so bad they couldn't even put her shoulder through range of motion exercises. And so, but there's time and time again, there's issues like that where she would make a finding of fact, but it was just wrong. And, she said, well, as of July 2nd, there had been no complaints of shoulder pain. She had complained of shoulder pain to every single provider she had seen by that point, 3 different medical providers. It's in the medical records, it's clear. And so I just don't know if there was some confusion or maybe she overlooked some things inadvertently. And again, I'm not trying to be hard there, but that's what it appeared to me.
Part of the concern, it seemed to me, from the trial court judge is that the initial complaint at the first, or maybe the first 2 hospital visits related to the neck as opposed to the shoulder. Am I correct that the doctor's testimony in this case is that essentially that's fairly typical with regard to a shoulder injury, that you would expect that initially some uncertainty in terms of neck versus shoulder?
Yes, sir. Dr. Dalal did testify about that, how they can kind of mimic each other, the neck and the shoulder. They're so interrelated that oftentimes happens. And so just so it's clear, so the first day, the day of the wreck, she did go to Baptist Minor Medical complaining of neck and back. She got sent to the emergency room to get checked out, and again, it's complaining of neck and back. And then the very next morning, less than 24 hours later, she's back at Baptist Minor saying my shoulder as well. And yeah, but Dr. Dalal did explain that there's oftentimes quite a bit of overlap, and sometimes, especially at like a minor medical clinic where you're dealing with a nurse practitioner or maybe an internal medicine doctor, they may not catch that. Dr. Dalal says a lot of times you have to inject the shoulder to relieve the pain so that then you can put it through some of these exercises, these orthopedic exercises to make the diagnosis. And so he kind of explained that. Yes, sir. But at the end of the day, I think the evidence, Dr. Dalal's testimony, the two lay witnesses that testified, the appellant, she's been doing this job as a CNA, which is a physical job, for 10 years before this, never had any problems whatsoever. And then she gets involved in this wreck and immediately, starting that next morning, starts having trouble with her shoulder, to which she continues to have through today. And I feel like Judge Hurd almost took that as a negative, saying, well, almost inferring, well, she's got a physical job, and so maybe that's what caused this, but there's no proof of that. And the proof is really the opposite. I mean, she's at work that day, she's doing this job and not having any problems with it whatsoever until this wreck happens. Your Honors, again, the medical records, the early and often complaints of shoulder pain, it's not a situation where, a month or 2 later she starts having shoulder pain. I mean, it's literally the next morning. The photographs, the video that was introduced into evidence shows that this is a very significant impact. If you look at the photographs of that Dodge Charger, I mean, the front end, it's not just dented in, it's crushed all the way in. It's intruding into the engine compartment. It busted the radiator. The hood's buckled up. The Ford van, it's got damage to the rear as well. Obviously, it's a bigger vehicle. And then there's the distance between the vehicles, which you can see in the video and in the photographs. Ms. Payne said, well, we had stopped short of the crosswalk, and then we get hit, and then when the vehicle stops, we're out in the crosswalk, and you can see that. And so it was hard enough to, force this vehicle out into the intersection, so there's a very significant impact here that we feel certainly caused this shoulder tear.
I believe that Judge Hurd also, in her order, made a finding that there was evidence that the plaintiff had some type of a degenerative or ongoing or chronic shoulder problem. Was there evidence of that in the record?
no, ma'am. And that's just another one of these situations where I think there's, again, maybe just overlooking some things. But if you look at the MRI that's included in the exhibits at trial, there's not a single mention of any degenerative issue at all on that MRI. Dr. Dalal didn't say anything about a degenerative issue at all during his testimony. There's a finding of some mild acromial bursitis, which Dr. Dalal in his deposition, his testimony, actually, he said that was from the wreck. That could just as easily be acute as it could chronic or degenerative. And so it's almost like Judge Hurd just, again, I don't know if she just didn't remember or didn't look at it closely enough, but there's nothing in that MRI report that says degeneration at all. There's no prior medical records to indicate that she ever had a problem with this shoulder before. I just don't know how much more are you supposed to put in the scale to tip it, to make it be preponderance of the evidence. I mean, how many more experts do you have to bring in? How many more lay witnesses before it's enough? And so, Your Honors, we're asking that that decision of the trial court be reversed and remanded. I would ask that this be remanded to a different division of Shelby County Circuit Court. I know Your Honors are aware from the brief that there's a pre-existing relationship between Judge Hurd and one of the defense attorneys. That wasn't found out till the very last second before trial. About 10 seconds before trial, Judge Hurd made a comment. I did not have the full disclosure at that point. More was learned later. But I feel like the type of relationship between them, that's enough to make a reasonable person question Judge Hurd's impartiality. But even without that, though, it was just the manner in which that was disclosed. The case had been pending in her court for 10 months. Nobody said a word about it until right before the trial. That doesn't sit right with me. And it just doesn't. And I hope it doesn't for y'all. So the manner in which that was...
What's the basis for your request for disqualification?
It's the pre-existing relationship between Judge Hurd's son and Mr. Jacqueline, who's one of the defense lawyers.
Does the statute require her to be disqualified by that?
Well, I think it wouldn't be statutory, but it would. I believe the standard is if a person of ordinary prudence would think there's a reasonable basis to question the judge's impartiality.
But there's got to be some basis other than just because there's a relationship. You saying she's biased?
Well, I guess so. I mean, if my childhood...
Well, no, I mean, it's got to be something. You can't just come in and say, I want this judge disqualified.
Well, yes. I mean, yes, that would be the case. If my childhood best friend's mother was the trial judge in the case, Your Honor, that's not appropriate. That would be such a huge advantage for me over my adversary. And I would expect my adversary to tell me, I would expect the trial judge to tell me that 10 seconds before the trial starts. So, yes, I do think that she would be biased again, in favor of the other side. And again, it really.
Well, we can talk about the rest of it during your rebuttal time.
Yes, sir. Thank you, Your Honors.
Yes, sir. Hear from the appellee.
Good afternoon, Your Honors. May it please the court. My name is Craig Barnes, and I represent defendant Shelby County, Tennessee. And there are two things that are being appealed here. First of all, the plaintiff is appealing a favorable ruling in the trial court whereby she was already awarded $75,362 for medical expenses, lost earnings, pain and suffering, including $35,000 for the pain and suffering, and $25,000 for loss of enjoyment of life for the neck and back injuries. Plaintiff takes issue with the one claim about the causality of the shoulder injury. Second, plaintiff is also appealing the trial court's denial of what it found to be a meritless motion to recuse, and that the plaintiff did not raise until after the trial court had already ruled and made their decision on this. As to the standard review for the first issue, we're looking at this as de novo with a presumption of correctness for the trial court's findings of facts. This rule applies to the courts to defer to the Court of Appeals to defer to the trial court's finding of fact. And findings of fact must be afforded a presumption of correctness and not be disturbed unless preponderance of evidence is otherwise. This was an accident. The facts were fairly simple, and liability was basically stipulated. We have a situation, though, where the plaintiff still has to prove the elements of negligence, including causation and fact. And to do that, the plaintiff would have to bring forth a medical expert and to show that the medical expenses were reasonable and necessary, and to establish the physical injury of the cause and fact injury of the incident. Now, the trier of fact, according to Roach v. Dixie, is not bound to accept expert witnesses' testimony as true, and it may reject any expert it finds to be inconsistent with the credited evidence or is otherwise unreasonable.
Counsel, is there any countervailing evidence, though, in this case? And there's no contrary medical evidence? I mean, there's one expert that testifies, and that expert seems to explain away a number of the rationales that the trial judge seemed to rely upon. And what's the basis for this conclusion?
Well, I believe, again, and this is the plaintiff's burden. The plaintiff has the burden. The plaintiff has to present the preponderance of evidence. As we go through the thing, that the trial court can look at the evidence that's produced by the experts. They can look at the exhibits. There are pictures taken by Officer Lang. There was testimony by Officer Lang, I guess if we're getting into that, also Officer Jennings. They talked about the circumstances of the accident that they were obviously part of, about the force that was involved in it. Officer Lang went and took
Let's take the force as an example here. And doesn't the doctor testify that you don't need sort of an incredibly high level of force to cause this injury, that in fact the shoulder can be damaged at a relatively low amount of force given the nature of the body essentially in that area?
Right. The doctor does testify to that, but also the trial court found that Dr. Dalal did actually not know how the mechanism of the accident occurred, how the specific injury to the shoulder occurred. On cross-examination, Dr. Dalal was asked if he knew the specific mechanism, and he responded no. The Dr. Dalal basically said he had to rely on the plaintiff for the information of how exactly this accident occurred. And the plaintiff told him that she was wearing a lap belt and that she was jerked forward. Okay, but he said again that he only knew what the plaintiff told him. He had to rely on the testimony of the lay witness.
Is the evidence inconsistent with her wearing a lap belt and being jerked forward when the accident occurred?
It doesn't explain how specifically she injured her shoulder. It certainly could explain how she injured her neck, could explain how she injured her back. But he didn't have that information. He wasn't there. And again, there was no other lay testimony specifically about how that happened. So I'd argue that no, it did not explain it. And this is obviously something that the judge and their ability to look and consider expert evidence, which is not conclusive, which he can decide how much he wants to weigh the evidence one way or the other. Expert evidence is assistant to the court, but again, not conclusive. So she found doubts in the way that he actually understood the mechanisms of the accident, which would go to his credibility.
Speaking of credibility, did the trial court make any credibility findings?
Okay, the trial court did not specifically make credibility findings, but when the trial court was, of course, listening to the other lay witnesses, and that she could make understands in terms of her interpretations of how that evidence might have related back to the expert. Again, and he cited case law of this, the expert can rely on, they can put a combination of what the expert knows from the expertise and looking at what the lay witnesses have. And she can certainly make those credibility decisions about how she looks at the whole case, whether she looks at things as being consistent or inconsistent. For instance, in that. So that was one of the things there. Now, I want to address this again, and Roach v. Dixie cited the Dickey v. McCord in the briefing, and this is the argument he's going to make, or I'm sure he will make in his rebuttal on this, is that you're saying that there's an expert witness. There was no countervailing expert witness, so he wins, right? Well, no. Even if there is no countervailing expert witness, if it's unimpeached and it's unchallenged, essentially, the trial court, according to Dickey v. McCord, quote, even in those instances in which there is no expert evidence offered, the trier of facts is still bound to decide the issue upon its own fair judgment, assisted by expert testimony. And this is especially true when the opinion amounts to no more than prediction and speculation. So what our argument here is that the expert, not knowing the mechanisms exactly of how the shoulder injury occurred, was engaging in prediction and speculation. This is the exact kind of thing that a trial court can turn around, can look at, and can find issue with. And that's exactly what the trial court did specifically in this case. The other thing to understand is, okay, this was a fairly simple trial. It didn't even take a day. But the trial court listened to 5 witnesses, including Dr. Purville's deposition testimony, and then took a minute, and more than a minute. The trial court actually announced that it would carefully review the medical records. And these weren't just a couple of medical records. There were hundreds of pages of medical records. And that she would spend, and did spend, 9 days reviewing the record. This was not a quick off-the-cuff decision where she just heard the witnesses and just acknowledged the records. She spent 9 days considering witness testimony. I think there were 12 exhibits, including video on exhibits 11 and 12 on the record, and she made that decision. So this was a carefully considered analysis by this trial court. And again, just to remind her about the level of consideration here, that she...
Counselor, are there some
I'm sorry,
problems though with those
assumption
factual-
of correctness
with
standard.
regard to those factual findings that were made? And
Yes,
so,
Your Honor.
for example, she doesn't make any determination related to not making complaints about her shoulder, but it seems pretty clear that they were, maybe not at the first hospital visit, first day, but fairly quickly, there's a complaint about her shoulder. Is opposing counsel suggests that that's a factual error and it's something the trial judge just got wrong? I mean, she said...
Let me address your question directly. Okay. There were, between the accident, there were 7 different times she went to Baptist Minor Medical. She went to also St. Francis ER, an emergency room. She went there to each or both of these 7 different times between the accident and June 16th, 2021, and between July 2nd. Every time she went there, her primary complaint was pain in her neck and her back. This is consistent. This is in the records. When there were mentions of shoulder pain, it was something about pain radiating down to her shoulder blade. But if you look at the diagnoses, and she went to not just the minor medical, but to an ER. So you had ER docs looking at her. They never once diagnosed her with a shoulder injury. There was no diagnosis of shoulder cuff injuries. They diagnosed her with acute midline low back pain without sciatica. And they also diagnosed her ultimately with essentially a pinched, bruised cervical nerve. So they had a chance to look at that. Again, it was not her primary
One thing
complaint.
I struggle with the primary complaint argument there is the doctor testified essentially that it's a fairly typical reaction in terms of thinking neck, but it's actually shoulder. And there's no countervailing medical evidence. I mean, maybe that's incorrect. And maybe if you hurt your shoulder in an accident, you know right away it's the shoulder, it's not the neck. How can the trial judge get to the conclusion here if the only expert testimony is that oftentimes it will present as the neck, that's where you'll experience it, that's where you'll sort of notice the pain, tell the doctor, but really there's something also going on with the shoulder when there's no countervailing medical evidence that suggests that understanding is incorrect that the doctor's providing?
Well, I think in a lot of these things that if you look at the evidence as a whole, and that's what she was doing, she's looking at the exhibit, she's looking at that, she's looking at those things. I think, again, I mean, what the plaintiff was complaining about, the plaintiff, even when initially after the accident, complained, I think, to one Shelby County sheriff's officer about some pain. But her primary concern, even in the accident, when the Shelby County officer Lang came up to her, was not about how injured I was and that I wanted an ambulance. It was, give me the report number. Okay, you got to understand, this plaintiff, and this is within, I think, 7 years, filed 3 personal injury cases and settled them, and this was the 4th in the 8th year. She seemed a lot more concerned about whether or not she had stuff to go for a lawsuit than whether or not she was in some kind of significant pain. So we're starting with that. And again, she went through and she did repeatedly talk about this is neck pain, this is back pain. We lack diagnoses. There's no reason why an ER doc couldn't have diagnosed her correctly here. And then there are the other issues, and I think just looking at the evidence of the whole and that, and when she was determining whether the plaintiff, had achieved the preponderance of evidence, which, like you said, is a high level to achieve in order to actually prevail on her case. She looked at whether Dr. DeLaw had, there were some suggestions here Well, she found that Dr. DeLaw had actually diagnosed this subchromial bursitis in the right shoulder, this impingement syndrome, these other things. These are things that, I guess, built up doubt in the mind of the trial court as she was looking at the evidence of whether he achieved this high level of standard of proof that he had to do. And that is on the plaintiff. It's not on the defense side to prove the case. The plaintiff has to prove the case. And she went through in her analysis, again, considering the standard of care here, that we have the presumption of correctness with the trial court, is that she looked at these things. She looked at the medical records. She looked at them for over 9 days.
Mr. Barnes, let me
yes.
ask you a question.
Sure
I
thing.
want to ask you the same thing, or one of the same things I asked your opposing counsel. Judge Hurd found in her order, made a finding, I believe, that there was evidence in the medical record that the plaintiff had some sort of a degenerative condition in her shoulder. Was there evidence in the medical record to allow Judge Hurd to conclude that?
Well, she was based this on, there was the testimony, looking at the testimony of Dr. DeLaw, and that's what he had testified. And these are records and MRIs. There was, I think, in his notes, in the record, it describes when the plaintiff came in, she described what had happened. Again, she didn't describe exactly how her shoulder got injured. He took MRIs. They did medical. That was where the medical evidence came from. So I guess that's the answer. It's from Dr. DeLaw's own notes. And to switch gears a little bit on here, he had filed this motion of recusal. There's 2 things I think I want to make a point of. First of all, what he's alleged that the basis for recusal is not a basis for recusal. It doesn't rise to the level that would require any recusal. I cited Boren v. Hill-Boren. One cannot, that's actually for a different thing. The main case decided, and there's this case in Cannon. In Cannon, the Supreme Court considered this and found that the mere existence of a friendship between a judge and attorney is not sufficient authorization for a recusal. And in Cannon, you actually had a situation where the attorney and the judge had gone on a cruise, on a vacation, hung out at each other's houses, and the DA in that case actually said that, well, we were close friends. But the Supreme Court found that that wasn't sufficient for recusal. In this case, co-counsel R.H. Chip Shockley had hung out with the son of the judge in the 1980s, nearly 40 years ago. They were not neighbors. They didn't go on vacations. And today, the attorney does not have any personal relationship with the judge. It is only professional. And if in the Cannon, if the judge found that that wasn't sufficient, that the friendship of the attorney and the judge, then certainly something as distant as this would not be a basis for recusal. Secondly, basically, he found out that the relationship existed prior to the trial. It was brought up that the judge had a cake recipe from the family from 40 years ago and mentioned before that her child and counsel had been friends in the 1980s.
Counsel, I have a question.
Yes, Your Honor.
If I recall correctly, there's a reference that may have been aware as early as May 2023, so before the date of the trial, right? What is that in reference to? The may have been
The trial court stated that they're basically, that's what the trial court had said, that she may have disclosed this as early as May. But whether it is May or whether it was a few minutes before the court case here, for the purposes of the argument and the proof, it doesn't really matter on that. Because, and I'll quote one of the cases that he cited, Gottwald v. Gottwald, quote, "It is well known and well accepted that a party must complain and seek relief immediately after the occurrence of a prejudicial event and may not silently preserve the event as an ace in the hole." I would basically present here that he used it as an ace in the hole. He waited until after the trial court came, gave his client $75,000 for the other injuries, but didn't give them the $400,000 to $500,000 he was seeking. And at that time, and only that time, did he bring up this issue of recusal for the judge. Thank you very much. I ask that the trial court confirm that the Court of Appeals confirm the trial court's decision on both of these issues. Thank you.
Thank you.
Your Honors, I did just want to state that my counsel opposite mentioned that Dr. DeLaw didn't know how the wreck occurred, but you can look at his testimony where he clearly testified that this was a rear-end collision where her body got thrown forward. His medical records reference the exact same history that was given to her at the time of treatment. And so he knew how this wreck occurred, and that's another one of these errors that Judge Hurd put in her findings of fact, that Dr. DeLaw had no idea how the wreck happened. He testified at the trial through deposition, of course, how the wreck happened. And so it's just another error that, it just, when you take away all those errors, there's not a whole lot left to support her ultimate determination that the right shoulder injury was not caused by the wreck. It really honestly appears somewhat arbitrary once you take away her factual support, what she claimed to be factual support. He stated that Judge Hurd took 9 days and reviewed everything so closely. But again, I almost wonder if the 9 days was part of the issue here. If had she rolled from the bench when the information was fresh in her mind, maybe some of these errors wouldn't have been made.
Excuse me just a minute.
Yes, sir.
There you go.
Oh, do I need to take a minute off
No,
or so?
no, just go ahead.
Okay. Maybe that was part of the issue. I don't know. But
I've got a question for you on the recusal.
Yes,
So let me jump back to that issue for a moment. And were you the trial counsel?
Yes.
Okay. So if I'm correct in looking at your briefs, you alleged that the first knowledge of this connection between the judge and your opposing counsel, the first knowledge you had of that was immediately before trial began.
yes, ma'am.
And you did not raise any question as to that until after the trial was over. Is that correct?
Correct. So I'm sorry, you want me to?
But go ahead.
Oh, I was just going to say, 10 seconds before the trial started, Judge Hurd made an offhand comment that Mr. Jacqueline and her son were friends as small children, and that she had a chocolate cake recipe of the mother's, and that was it. And in my mind at that point, that doesn't seem like something for recusal, right? But it turned out to be much more than that. They were actually best friends for many, many years. Mr. Jacqueline spent a lot of time at the Hurd household.
But you felt the need at some point to obtain more information about that, correct? You felt that you needed more information about that?
Yes.
About that
Yeah.
relationship?
Yes.
But you didn't raise that issue until what point?
Well, so there was that 9-day gap between the trial and when she made her ruling. And I mean, during that period of time, I'm thinking and I'm talking with people, and, basically what I'm thinking at that point is, okay, there might be more to this. I didn't know. I mean, I didn't know for sure. How was I supposed to know this without the other side disclosing it? So basically, I'm kind of in a position where I'm sort of guessing a little bit. You hate to do that, but it turned out to be correct here that there's a lot more to it. And it's just disappointing the way that it came out.
I guess what I'm asking you is, it seems like that's quite a while between you heard something, trial had not yet begun, and you could have said something at that point, but instead that happened 9 days later. And I'm trying to understand why that occurred and why that's not too long of a time period, to be honest with you.
Right. I'll say this. Literally, we're about to give opening statements is when I heard this comment. My focus is on the trial, my opening statement, the witnesses I have lined up. You know what I mean? Like, I'm so focused on that. It's not till later that I'm thinking, why did she say that? Maybe I should have said something at the time. Maybe I should have, but at the same time, isn't there an onus on the other side too to make a full disclosure? That's what you see in most of the case law, is that there's a full disclosure early on. And then if someone doesn't take advantage of it then and raise the motion for recusal, that's when they've waived it. That's not what happened here at all.
Okay, thank you.
So yes,
I have
sir.
a question. So we've established that the relationship, or at least in my mind, we've established that the relationship does not require disqualification. Because it's not the judge, it's the judge's son, and based on everything that I've heard thus far, we're talking about a childhood relationship 40 years ago. So that doesn't qualify under the statute. So it's got to be something else. You're telling me it's bias, prejudice, is that accurate?
Yes, yes.
And tell me, what instances or what has happened in the trial court other than you got a decision that was not as much as you wanted that you're relying on? What specific instances are you relying upon to show bias or prejudice?
Well, I mean, when I see repeated, numerous findings of fact that are just factually incorrect, objectively incorrect, you know, that is what I'm focused on.
Are you aware of what the law is on that?
Your Honor, I'll be honest, I've never filed a motion to recuse. I've been practicing 20 years. It makes me uncomfortable even having to do this. I'll be honest, I don't know all the ins and outs. I just know this is not the way it should have been done, in my opinion. There was some background, a relationship there that wasn't disclosed. It was a partial disclosure, and it just put me in a really weird spot. And I don't think it's appropriate. But yeah, to answer your question, no, I don't know all the specifics on the law on that issue. It's
Okay.
probably pretty high, obvious.
Thank you.
Thank you, Your Honors, for your time.
Thank you, counsel. We appreciate your argument. We'll take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused.